We are on air. We should be live. Let me know if you're seeing us live. We should be on. Thank you for joining us this afternoon. We should be in the midst of your lunch hour, joining us for this talk on immigration. I'm Sasha Watson Sankley from HAWM Law, where our motto is having an attorney when it matters. If you need to contact us today for any legal advice, we do offer limited free consultations. You can reach us at 407-802-3223. What we'll be talking about today, our focus is immigration. There has been so much that has been going on in immigration for the last roughly 30 days now. It's been a buzz topic on the news everywhere. President Biden and his new administration are, full steam ahead with immigration policies and reviews. And for us as immigration practitioners, we like the movement. We like where things are headed. It's definitely positive for us right now. We just went live on Instagram. So thanks for all our Instagram followers who are joining us live. This is our first Let's Talk Live with the ladies of attorneys of HAWM Law. Welcome. We are live today on Facebook, Instagram. Hopefully our feed is live on LinkedIn as well. So we look forward. So the first thing, let's jump right on ahead because we have so much material to cover in the area of immigration today. And if you have questions, put your questions out there. I'll try my best to get to them and to answer those questions today. Hold on, I'm having some technical difficulties here. Let me make sure we are live on Instagram for us. Let me do that. I was just told to go live on Instagram. All right, so I think that's coming up. So our Instagram followers should be able to follow us. All right, we are live on Instagram now. So the first thing we're talking about is Biden's new immigration policies. One of the big things that he is proposed is the U.S. Citizenship Act of 2021. For what I want people to know is that this is currently not law, right? It's nothing official yet. This is a proposed bill that has to work its way through the U.S. legislature and Congress, right? So this is not actually law yet, but it is the proposal, and it's a good view into the mindset of this administration and their immigration policies going forward. Of course, there will require, some bipartisan efforts from Republicans and Democrats to work together to actually get this bill passed or portions of it passed, and for us to have some real immigration reform. But there are some good things in this bill for us to discuss. And we want to make sure that you're aware of where immigration policy in the country will be headed under the Biden administration. So with the U.S. Citizenship Act of 2021, there's a couple things to focus on. It outlines a pathway to citizenship for the undocumented within the country. There is alleged to be roughly about 11 million undocumented workers in the United States. And with this bill, the goal is to regularize or to legalize those individuals' immigration status. So with this, they would be offered a 5-year temporary legal status in order, and then after that, they will be able to, the temporary legal status or green card, and then they would be able to go on to apply for U.S. citizenship. So it's temporary legal status for a period of time, then you get your green card, and then you would get your citizenship. But it's a 5-year path and to the green card, and then a 3-year or 5-year path to citizenship, right? Which is the naturalization process. It would immediately allow our dreamers, which is the children who are eligible for DACA, to go on and apply for their green cards now, if this were to ever to become law. Also with people who are currently in the country under TPS, they would be able to have that ability as well to go ahead and immediately apply for their green card. So some relief to the individuals who are living in the country with a very uncertain and unsustainable legal status in the country. So it's very important that this gets looked at. But like I said, this is still not currently law. Another part of the U.S. Citizenship Act is being able to reduce that significant backlog. If some of you have applied, you definitely realize and you know how long this process is taking. If you've applied for a brother or sibling application, those applications are well in excess of 13 years right now for a visa to become available. So one proposal under this act is to reduce that significant backlog, speed up the process to family reunification by allowing persons who are actually waiting for visa availability to be able to come into the country while their application is pending, and have that family reunified and not have them living separate for such a long time, waiting on the immigration process to catch up, right? Protecting U.S. workers is also a central and important part of the proposed bill. So although they will reduce the burdens in the administration, they want to also look at protecting U.S. workers by making sure that individuals who hire foreign workers are paying those foreign workers the salaries that they should be paid, not lower salaries, but market rate comparable salaries, that the working conditions for individuals who are in the U.S. working are of a certain standard, because that affects all the standards across the board. So that is also critically important to the process. Addressing issues of our asylum seekers and our vulnerable populations. So individuals who have been trafficked, in children is important. One of the most important parts of this proposed bill that, we welcome as immigration practitioners is affording legal representation to children in the immigration process, because that is critically important. Right now, even children, they're not entitled to have legal representation. So we've heard of, some egregious situations where children as young as the age of 4 and 5 are having to represent themselves in immigration proceedings, which can be immensely complex, as you can imagine, for an attorney and an immigration practitioner, much less for a child to understand. So including some of those protections is critically important to the immigration system and the integrity of the system that we're trying to build here in the U.S. Also important is, of course, border security. Do not be misled by, possibly news publications that say that, the Biden administration is trying to let everybody and their auntie, uncle, and cousins into the country without any protections. This proposed bill has as a central focus border security, securing our national security, making sure that funding and the technology and smart technology is being put into place to secure our borders so that we can have a robust immigration system, a robust border to protect all of us in the country. Even the immigrants coming in want to have that secure border in place. So there are measures for that. And also a critical component of this bill is going to be trying to focus on what are the root causes of migration. We've seen on the news these migrant caravans coming into the United States at our southern border of thousands of people. And really, they want to put funding in. How can we correct the problem at the source so that we can prevent people wanting to flee their countries, right? And the question people will say, well, why should that be our problem? Well, it's our problem because they're trying to come here. So if we can prevent them from trying to make the attempt to come here from the very beginning, and stay in their countries and live their lives, that'd be great for our border security as well. But that's coupled with some of the technologies and protections at the border community. So that's really the crux of this particular bill. The most important thing is that I want the public to understand is that this is currently not law. There is no new immigration law that allows you to go and apply for a green card if you've been undocumented for a significant period of time under the Biden administration, right? However, we do have some laws. We already have a book of immigration laws, the Immigration and Nationality Act, that outlines mechanisms for people to get legal immigration status. And my advice to you, the one thing that I can give you today is to really tell you, work with the devil that you know, right? And the laws that we have do provide various channels to get legal status. So don't wait. Don't sit around waiting and hoping that Biden's bill is going to pass and this is going to happen and then I can apply for my green card. Sit with an immigration attorney and find out, are there avenues for me to get legal status in the United States now under the current laws that we have, right? Because one of the issues that we have is that, yes, maybe we get some parts of this bill, but there will be some areas that the government will have to make compromise. And that may make some immigration issues more difficult for certain individuals in the future. So if you can find a way to get your legal status now, it's best that you pursue those avenues and not wait, right? Another thing that President Biden has been doing in the immigration arena is to use his presidential authority to issue executive orders to try and alleviate some of the problems that we have in the immigration system, right? Executive orders are not necessarily laws, but there are policies from his administration that the government will typically have to follow. Some of them have already been challenged and are working their way through the court system. But there are some that have been put in place that are critically important, right? One of the ones that we're focusing on, that we're looking at, is the change in enforcement priorities with the Immigration Customs Enforcement. That's really good. So what they're looking at, and this kind of harkens back to the Obama years, where the government really strategically tried to spend their money and resources to target criminal aliens and some of the most serious criminal aliens that pose a threat to national security. They really focus on people who have been convicted of aggravated felonies, as that term is defined under the Immigration and Nationality Act. So you're looking at some of the most heinous individuals being targeted for removal from the United States. And there was at one point, the administration had issued an order saying that there would be a pause, a 100-day moratorium on deportations from the United States. So that was in one of the executive orders. However, a court out of Texas has issued an injunction against the government, barring them from enforcing that particular part of the executive order and the issued policies that they have set out. So there is currently no moratorium on deportations, but the government is taking the approach, we're new administration, let us make an assessment of what needs to get done, so we want to pause this. But that's been enjoined by a court out of Texas. So for enforcement priorities, the government is now looking at and targeting for removal, like I mentioned, people who are threats to national security. They're being targeted. People who have been apprehended at the border anytime on or after November 1st of 2020. So if you are caught illegally entering the country after November 1st, 2020, and you've been detained, or you're found to have entered anytime after that, you are a priority for removal from the United States. And then anyone who is a public safety risk, right? So, for example, if you have been convicted of an aggravated felony, and that can range in terms of the crime, but your most heinous crimes that you can think of will be covered under the definition for aggravated felony. What does it mean for you as the public practically when it comes to enforcement priorities? This means that if, for example, you are currently in deportation proceedings and you may not, or you have a family member who is in detention, being detained in an immigration facility. If they don't fall into one of these categories for actual removal, they're not one of the enforcement priorities, we now have the option to go in and apply and ask for reconsideration of bond for their release. We have the option of making some motions to the court to possibly terminate your immigration proceedings, asking the government to join in on reopening some deportation proceedings to allow you to apply for certain types of relief, as well as join in different motions to the court to either terminate your proceedings, grant you the relief that you may be seeking, as well as what's called prosecutorial discretion, right? And it's an important thing that the government has as a tool to determine who we should be targeting for deportation, and that's prosecutorial discretion. And it's kind of disappeared under the Trump administration, but now it is an effective tool that attorneys will have again to be able to give immigrants some relief. And what prosecutorial discretion really addresses is, does the government have to issue you a notice to appear in removal proceedings? Does the government have to actually put you in proceedings and deport? Do they have to detain you? That's what we're talking about when we talk about prosecutorial discretion. Can they join in on a motion to terminate these proceedings, right? Based on some avenue of relief that you may have to allow you to apply for that, even though you may still technically be deportable. The government can use its discretion to prosecute. And that's a powerful tool that we now have again to be able to address and some of the immigration issues that our clients are facing, right? So that's talking about enforcement priorities. Because of COVID, right? Before I even get into our COVID section of the program, the immigrant visa and non-immigrant visa ban that came into play under the Trump administration last year as an attempt to protect U.S. workers. Many of you may recall, the unemployment rate in the U.S. shot up to 14% in about early April last year. And so as a tool, the government said, we're gonna pause issuing certain types of visas, right? Including green cards to family members who've been waiting because of the backlog for a very long time, and including some of the non-immigrant type visas, such as the H-1Bs for skilled workers or the L visa for intra-company transferees. They put a pause on the issuance of those. And that pause is actually still in place until March 31st. Before President Trump left office in December, he extended that immigrant and non-immigrant visa ban. And so those are still active and in place. And those apply. There are exceptions, right? So even if you are thinking, hey, I'm an immigrant, I have a green card application that is pending. Am I subject to the ban? There are some exceptions, and the exceptions generally will include if you are a spouse or a child of a U.S. citizen, if you are a lawful permanent resident. Those are some of the typical exceptions. But let me talk about the immigrant visa ban at first, right? So what it was is that if you were outside of the country as of April 23rd, 2020, last year, you basically would be subject to the immigrant visa ban under Presidential Proclamation 10014, right, which suspends entry of immigrants who pose a risk to the U.S. labor market, right? And that's the target of this, is the protection of U.S. workers and getting the unemployment rate down, right? Exceptions, like I said, lawful permanent residents, individuals and their spouses or children. So if you are filing for a spouse or a child under 21, they would not be subject to that ban. It doesn't necessarily mean that the visa is going to be issued immediately, because unfortunately at the various consular posts around the country, there are operational issues that have caused some of those embassies to either remain open or to be working at a reduced capacity. And because of that, there is still a wait time for processing the visas, but they should be processing those. And you may be able to get, if you have an emergency situation and you know your visa is available, or you had an interview that was scheduled, or we're able to try and facilitate based on that emergency or national interest need to get that visa process as quickly as possible, right? One thing to note that the immigrant visa ban does apply to parents of U.S. citizens. So if you have filed a petition for your parent, they are subject to this ban, right? Even if you are a U.S. citizen. So you will have to wait until this ban does expire before the embassies can issue a visa to your U.S. parent, right? Another exception to that is if you have children that you're applying for and they possibly may age out, right? Meaning that they're going to change categories and they may not be eligible for a certain visa anymore. Those are exceptions to the ban, and they're going to be considered emergency and mission critical services, and therefore the various consular posts and embassies will be able to process those visas. But it does require some action on your part, right? You will have to contact the embassies, notify them of what's going on. Unfortunately, the system is not necessarily seamless to make this happen. So it does require us to take some action to notify the embassy and say, hey, listen, I've applied for my child. My child is there by themselves. They're about to age out. We need you to process this application as soon as possible to give them this benefit timely. And that's something that an attorney can assist you with. If you are just tuning in to us, this is Let's Talk Live with HAWM Law. This is our first live stream. You can call us for a consultation. The number is here on the screen. And we definitely are here to serve the public. So we do offer free consultations in some areas and limited free consultations in other areas. So if you do have an issue, there is no excuse to get the legal advice that you need, especially in the area of immigration law. You definitely want to seek some legal advice before you put your foot out there and move forward with that. So let's talk about moving on. Let's just talk about real quick, touch base on the non-immigrant visa ban, which is Presidential Proclamation 10052. With that particular ban, it currently applies to H-1B, H-2B, L-1As, L-1Bs, which are our executives, our managers, our specialized workers, and some of the J-1 visa applicants, right? There are some exceptions as well to the issuance of these. If you are coming into the country to work, for example, in the healthcare field, to help fight COVID-19, you can apply for a national interest exception to the ban and to be able to have that visa process. There are some litigation that's moving their way through the court system, especially on the H-1B program. So you just have to, really keep abreast, stay attuned. What I suggest that you do is, because we post, content on our websites all the time with updates on what's going on. So if you are not aware and you want to stay abreast of what is really happening in the immigration field, like us on Instagram, like us on Facebook, follow us on Instagram, subscribe to our YouTube channel, right? You will get these posts on a more regular basis as we progress through 2021, because there is so much that is going on, right? Travel. Question that we've been getting lately is, can I travel back into the United States? What is going on with the travel restrictions, right? So on January 12th of this year, the CDC issued a new requirement that anyone traveling into the United States from an international location would require a negative COVID-19 test result. That test result has to be checked by airline, has to be given to the airline. So it's going to be when you go in to check in for your flight, you have to produce your negative COVID-19 test. That test has to be one that was taken within 3 days before you board your flight, right? If you've recovered from COVID-19, you may not need a negative test, but you have to be able to document and show the airline that you have already recovered from COVID-19 in order for them to board you. So the checks and balances on this, or the gatekeeper for this testing, is happening at the airlines, and I'm assuming that information is then being passed on to Customs and Border Patrol, right? The government, President Biden, did issue an executive order that does talk about the travel restrictions and what will be required. For example, they're requiring individuals to definitely wear masks on federal property, which includes airports. They're on certain bus services, trains, things like that, that are controlled by the federal government. But what the government has said is to tell these various agencies, go back and make an assessment on what the best policy should be and give us that information, right? So we don't yet have the final policies on what the travel restrictions will be. They were supposed to issue some policy guidelines back on February 3rd. That may have occurred, but they're waiting to publish to the public what the final results of that will be. So you could expect that in the future, there may be some additional requirements, right? You may have to quarantine. You may have to have COVID tests upon arrival into the country or shortly thereafter, but we don't know those details. The only thing that we know about the traveling so far, as in coming in, is that you will be required to take that COVID-19 test 3 days before. Oh my gosh, we are moving so quickly out of time. Let me jump through other parts of the program. So COVID-19 and immigration, and I want to touch base just quickly on certain accommodations, I'd say, for lack of a better word, that have been put into place as a result of the COVID-19 pandemic to deal with immigration issues. So one of those things that is the USCIS, which is U.S. Citizenship and Immigration Services, has extended its flexibility policy to responding to certain agency requests. So if you've been issued, for example, a request for evidence, a notice of intent to deny an application, a notice of intent to revoke or rescind, or you've gotten a denial letter of some sort, or you need to file a motion to reopen, for example, a citizenship application that you need reconsidered, the government is giving you additional time to do those responses. However, the government is a big system. So when you get your letters, it will typically say you need to file a response within 33 days, 30 days, whatever the applicable time frame is for your application. But the government, on top of that, will give you an additional 60 days to file your response. So if it was a 30 days to file a response, you're now looking at 90 days within which you have to file. So be mindful of that, because if they're asking you to get, for example, on a request for evidence, certain documents, it is taking additional time to get documents from various third parties. So you don't want to sit on these requests just because you have the additional time. You definitely need to be proactive and diligent at trying to formulate your response to the government. But there are some flexibilities in that. The other aspect that I want to talk about as well with respect to COVID-19 is verification of employment, because we've gotten a lot of questions about this. I need to produce to a new employer a driver's license, proof of my work status, but I haven't gotten the documents back I need from the government. For example, your employment authorization document or card is delayed. You've been approved, you still haven't gotten that physical card in your hand. There are some accommodations at USCIS. They have instructed that employers are to accept just your receipt notice. They are saying that if your state has clearly stated that there is a delay due to office closures, quarantining and they have automatically extended the validity of your driver's license or your state ID, that employers are supposed to be taking those documents as valid verification of your employment for the I-9 verification process. Also, if you are getting a new job or your job is doing a re-verification of your I-9 and your eligibility to work in the United States and you're working remotely, they're allowing them to do a remote verification process utilizing copies of the documents, using household members of yours for the verification. And there are stringent guidelines for their employer to follow. But what I want you to be most mindful of is that you should not be denied employment because you have produced a document that is valid by the US government for proof of employment, but your employer refuses to take it. If that is happening to you, you are being discriminated against, right? On account of your immigration status. And that is a violation of the law. And if you're in that position, you need to contact an attorney. You can contact our office and we can walk you through the process of filing a complaint. If you are an employer running a business, make sure that you are not asking foreign workers or non-US citizen workers for documents above and beyond what is required by the US government. You cannot force an immigrant or a green card holder or a person with a work permit, employment authorization document to produce additional documents just because, right? You have to allow the employee to choose which documents they want to produce from that I-9 list of approved documents. Otherwise, you are running afoul of the law and you could be subject to civil fines, which can be quite hefty. So be mindful of that. Be mindful of your own status and that you're doing all the right things. So let's talk about the other thing that I wanted to mention before was for the Liberian Refugee Immigration Fairness Program. And I just wanted to drop that in that has been extended until December 20th, 2020. So if you are a Liberian national, you're living in the United States since November of 2014, you're not subject to inadmissibility because you have crimes or certain things like that. You can apply for temporary status in the United States and obtain a green card. So there is still another year to do this. It was set to expire in December of 2019, but it has been extended. So if you know anyone who is Liberian, who has the ability to apply for this, go ahead and tell them to contact us right away. So let's get this done because the clock is ticking on it, right? And it's a beautiful program. So the primary applicant has to be Liberian, but it can also cover your spouse and your children who are not Liberian nationals. So just keep in mind of that. So what I want you to leave you with today is what should immigrants be doing? What should you be doing now, right? Like I said, we don't technically have any new laws under which for you to apply for citizenship, but you definitely want to go ahead and consult with an attorney if you don't have legal status to figure out, is there anything I can do to get my legal status under the current laws? And there's, the immigration law is very extensive. And there are many different avenues. If you really sit down and get to the nitty gritty of your situation, there possibly could be some relief under the current system for you to get legal status, right? Marriage-based cases, if you are filing for a spouse or you're the spouse of a U.S. citizen, the public charge aspect. This came in under the Trump administration, and there's been some tennis play here back and forth. Do you have to file these new public charge documents and forms? We don't have to file it. But as it works its way through the court system, it has gone back and forth many times. Currently, as of November, the public charge rule, the revised rules are in place. So if this is any kind of family-based case, you do have to, or any case really, you do have to prove that you are not a public charge, and you do have to submit these additional forms, declaration of self-sufficiency, and the supporting documentations that the form does require: proof of your education status, proof of your ability or your ability to speak English, or your diplomas, your education history. Your credit report is going to be necessary. And the question I get all the time is, how do I get a credit report? I know I'm moving fast. How do I get a credit report? I don't have a social security number. I don't have all of this. What you do is you contact the various credit bureau agencies and request, and they will send you a letter that says you don't have any credit history with us, right? And you submit that. You want to tell them what's your plan for getting health insurance, right? You also have to do that as well with the public charge issues. You want to go through that. So that is still in place. You want to be prepared. Anytime you're going for an interview with USCIS, don't take for granted the need to prepare for those interviews, right? Citizenship. If you've applied for citizenship and naturalization, and your application is subsequent to December of 2020, you're looking at doing the new exam, right? So the new exam has 128 possible questions. You can expect to be asked 20 of those questions, and you have to get 10 right in order to pass the civics and history portion of the exam. That's different than what you did if your application was prior to December of 2020. So make sure that when you're studying for the citizenship exam, that you are reviewing the correct set of questions and that you are prepared to take answer the 10 questions correctly. That's our program for today. Thank you for tuning in. I hope you enjoyed it. I hope that it is beneficial to you and your family members and your friends and your network. Please, if you have any legal issues, contact us. We practice criminal defense, family law, immigration, personal injury. Give us a call at 407-802-3223. We thank you for being here. We plan to be with you again to do these lives more often. We intend to upload this on our website. So if you were not able to catch the whole program, jump onto our website, www.hawmlaw, and review this clip. Like I said, it was great being with you this afternoon. And like we said, here's Alicia.
Happy Friday. Woo-hoo. Good job, Sasha. Thank you.
If you are running from the police, immigration, or your spouse, keep calm and call home. Have a great Friday, everyone.